193, People versus Varenga. Counsel?
Good afternoon. May I have 2 minutes for rebuttal, Your Honor?
2 minutes. You have it. Go ahead.
May it please the Court. I am Assistant District Attorney Thomas Costello for appellant. Your Honors, it is our position that...
Counsel, do they have only the 30 days, or is the 1 year tacked on to that?
The appellate division held, we believe erroneously, that the...
Why is it erroneous that
Well,
they get
for two main reasons. Number one,
again?
for two main reasons under two theories. Number one, such a claim as Padilla, which is based on matters off the record, could never form the basis for an appeal. So it doesn't make sense to count the time within which to seek an appeal or to file an appeal for the purpose of determining finality as far as Padilla.
What's the logic of that?
Well, it's called the pipeline rule, basically.
The what rule?
The pipeline rule.
Oh, right.
Which is, from Griffith, which is basically that when a new rule is pronounced by the Supreme Court, if an appellate court has before it a case that is affected by it, but it's not retroactive, but if the court...
But when is it final? That's the issue.
Then the court can determine it out of interest of
so
equity.
When is the time of finality? That's the question.
Well, that is an appellate pipeline. We're talking here about a post-conviction pipeline.
So what you're saying is we're not talking about finality on direct appeal.
Exactly.
Okay.
Exactly. We're talking about finality for purposes of Padilla.
Right. Go ahead.
On a 440. Because
ahead.
it can never form the basis for a direct appeal.
Go ahead.
So what other states have held, and I found this relatively recently, was that they will adopt a post-conviction finality pipeline, per se, for a case, say, that a judge has before him or herself a Padilla claim pending at the time of Padilla. That is basically when a 440 equivalent judge in another state has been able to contemplate a Padilla claim. After that, the case is final.
I lost
you. You mean till sentencing? Is that what you're saying?
Well, my first claim is that for purposes of Padilla, a conviction is final at sentencing. For other purposes, we're talking about Padilla finality. Mr. Varenga
Well, we're talking about Padilla today, but then are you saying that any claim that relates to something that cannot be discerned from the record and therefore is not subject to a direct appeal
that's why
falls within the same rule?
I think this could be an important case in the future for any kind of future Supreme Court case that affects ineffective assistance of counsel or anything else off the record.
Mr. Costello, I know in the Fourth Department, because that's where I used to be, if a notice of appeal is filed, it can be pending there for 10 years, 15 years, until and unless the people move to dismiss it, because the defense is never going to move to dismiss it. And for some reason, they never do. So all of the people that have filed notices of appeal, I don't know if this is true in the Second Department, but in the Fourth Department, that may have a Padilla claim, if they filed a notice of appeal and just took no action, but the people took no action to dismiss it, are sitting there. And I don't know that anybody, it used to be a complaint we would hear from this court saying, these are not final, and what are you going to do? Now, in this situation, you have no notice of appeal, right?
No notice of appeal.
And what you're saying is, therefore, they're not in the pipe. All the ones I just described would be in the pipeline that you're talking about, because all of a sudden, if Padilla came down, they could say, oh, hey, we never thought about this, but we can appeal because it's pending and they're in the pipeline and it would apply, right?
Well, they would be in the appellate pipeline. But
right.
What my position is that as far as a Padilla claim, there is a separate pipeline. There's a different pipeline for post-conviction 440 motions, and that why are we contemplating the year and 30 days for purposes of assessing a Padilla claim?
On Padilla, you're saying a 440 would be necessary.
Well, that is, I think, that the law, and Judge Littman himself, I think, stated that in his dissent in Barrett, which is these claims can only be brought by 440. There is one exception, that a defendant can move to withdraw his plea or her plea, but that has to be made and determined before sentence.
Well, what's your argument here? I mean, what should they have done then? Brought a 460-30 motion in order to qualify for the year in 30?
Well, no,
Almost done. And then once that's granted, assuming it's granted, now you do have the year in 30, and then you can do whatever you want, in your view, of 440 or whatever.
My position is 460-30 doesn't apply to these claims because they're not part of the record. They're not record-based, so that they can't ever be the subject of an appeal.
It's always a collateral issue.
It's always a collateral issue, except in that.
And Padilla can't apply retroactively because of Haidez and Barre. It can't be applied for collateral claim.
That is our claim. Now, I will acknowledge that there are courts that have said, this is the other prong of my argument, that a conviction is final 30 days after sentence. I'm not sure what statute they're looking at for that, but it is apparent from the lower court cases from the Bronx that I
But you want to
cited.
say it's final at the date of sentence, which would be something that we haven't done before.
Well, I think that is the most reasonable view.
Let's assume that we don't agree with that. All right. So
Then you
it's
go,
what-
hopefully, to my second prong.
Well, how does he know about the claim? This particular defendant on the day of sentence. When is Padilla rendered? Is it
Well-
rendered before the sentence, day of sentence, 30 days after the sentence?
Well, I mean, that's the whole issue.
That's the
It's that
conundrum, right.
as
So
of-
I'm trying to figure out how your rule works for someone like this.
Well, when the rule, I guess, would be that on the day that Padilla was decided, if the case is still pending, obviously, the attorney should have, post-Padilla, attorneys have to advise their clients. Pre-Padilla, it's not retroactive. We're talking about,
You're saying he's got 30 days from when Padilla is rendered? Is that,
well, yes, essentially, that would be 30 days after Padilla, or, yeah, and that I think.
and if the attorney fails to do that, does he get a year and 30 days after that to
No.
argue his attorney failed to file that notice of appeal?
No, Your Honor. It's the Padilla claim has to have been raised before Padilla, at the time of sentencing, or before.
At the
There
time
is
of the
no
plea.
Padilla claim at the time of sentencing in his case.
In Mr. Varenga's case,
Correct. Padilla is decided after that, isn't it?
right? It's decided
Right. So
after.
at sentencing, he has no clue.
Right. So that is basically our position: is that why are we allowing a defendant when Padilla is not the requirement? Why are we saying that an attorney has to have advised?
But I'm trying to understand your rule. Your rule is then 30 days from when Padilla is rendered, because now he has some claim. That's your argument?
The argument is either, for purposes of Padilla finality, a case is final at sentencing,
If Padilla had already been decided, is that what you're trying to say?
right, because we're counting from the date of Padilla, or based on the other
It could be the
cases that
same day, otherwise you're trying to apply it retroactive, but go ahead, okay.
well, I'm saying it shouldn't be retroactive, that it should be
I
applied
understand, that's why I'm saying the
as a
sentencing
data.
date doesn't necessarily make sense, but okay. Let's try it from the 30 days from Padilla. So my question is then, why doesn't he get the benefit of the year and 30 days after that?
Well, I'm saying, because it's a discretionary,
Okay, now we got
it's a discretionary motion,
Well,
first of all.
Aren't you saying the 30 days he's entitled to by statute, 46010, right? Let's assume that. However, the year is discretionary. It's not a would get or a must get or is entitled to, but it's a can get. Now, there are some departments, like the first department, which I understand grants all leaves, gives everybody a year, but everybody else does not do that. That isn't really the policy across the state. And that discretionary determination is to be made on an individual basis. And here, of course, it's important because we would be making a rule for the whole state. We would be taking away that discretion.
Right.
Yeah.
And also.
Because it falls after the 30 days, but before the 1 year is up, after the 30 days.
Yes, and going back to the last case, there's also.
But to hold otherwise means that similarly situated defendants might end up with a different outcome just because of the departments they're in, right? Because it is discretionary.
Well, right now, as far as I'm concerned, People v. Bent, which is the case that we relied on, where a defendant was sentenced after our defendant, Padilla was not retroactive. So the third department.
Well, was it raised in that case? Can we tell from
Well,
that case if the issue was ever even raised?
I don't know if the issue was raised and briefed and formally argued, but, I mean, in doing the analysis for finality.
The issue of whether that case was final, that was raised in bench?
Well, the court held that the sentence was final. So, I mean, if you don't look at the sentencing date, you don't reach the finality conclusion. So I think there was some kind of thought process there as far as finality.
You'll have your rebuttal.
Thank you.
Let's hear from your adversary. Counsel,
Good afternoon.
What's fair here? What's fair?
What's
for the
fair?
defendant? Yeah.
What would be fair?
From a policy perspective.
From a
what's fair?
policy perspective, it would be fair to issue a rule that a conviction becomes final 1 year and
Why?
30 days after sentencing because of CPL 46030. The legislature has created a statute, and we should honor that statute. We should honor that statutory scheme. The scheme that the prosecution is proposing is not a scheme that the legislature has adopted.
Counselor, what if that appeal is allowed and goes forward, and then don't our rules then also permit a discretionary appeal? So then do we extend the time to that period of time?
No, we would extend the time. I'm specifically referring to the time period within CPL 46030.
I think Judge Stein is asking, since there's a discretionary appeal to the Court of Appeals, or let's say we're talking about the discretionary appeal to the Court of Appeals, why aren't you also advocating for the addition of that time? Or does that only count if indeed the 46030 appeal is actually granted?
It applies. Keep in mind, the Supreme Court in Teague stated that criminal convictions do not become final until the discretionary time period has expired. Under Teague, discretionary time period.
You mean for the appeal as of right?
For the discretionary appeal. So, in essence, with the discretionary period, when calculating discretionary time periods to appeal, Teague states that you have to include that time period to determine when a criminal conviction becomes final.
Let me ask you another question. We've been talking about Cyville. Okay, so Cyville now has some exceptions already that say even the 1 year and 30-day period isn't, may not be final because there may be an exception to that. So then, again, aren't we extending it indefinitely under those circumstances?
No, we're not extending it indefinitely. I mean, the statute on its face grants 1 year and 30 days if the defendant meets the conditions, whether or not an appeal is filed. In this particular situation, my client met the statutory requirements in 46030. He had a counsel who did not properly advise him of the negative consequences of his plea. He had defective counsel. He wasn't aware he took a plea without the proper advice.
Mr. Szilagyi, am I pronouncing your name correctly?
Yes, Your Honor.
Shouldn't you be required to show that you're entitled to 46030 relief before you invoke that time period? Now, you're saying that he does.
Yes.
But no court has found that, correct? There's been no finding that he's entitled to a right to appeal.
Well, my understanding of the law is that if you make a showing under 46030, under one of the conditions, if you make a showing, the court must grant that application.
Well, as you were alluding to what we heard just a minute ago, if we were to affirm those in which they were denied, then they didn't qualify for 46030. They could not make the allegation that you're making, correct?
Perhaps. What's your specific?
I'm suggesting that shouldn't your client be required to show that he would qualify under 46030 before he can take advantage of that pipeline, as Mr. Costello calls it?
Well, for one, when we made the 440 motion.
Yeah, in other words, if he's successful on a 46030, using Mr. Costello's pipeline, he then has opened the pipeline. He's now in it. He's got a right to appeal, and he's got 30 days, usually from the date of the 460-30, to file a notice of appeal, and presumably he would do so, and now he's in the pipeline for Padilla purposes and all others. If he did not qualify, then he would not be in the pipeline, and he would not qualify for the Padilla relation back for being in the pipeline.
Well, I believe that the prosecution's argument is completely flawed because they're basing finality on the failure to file a notice of appeal, and that's not what the statute specifically says. And in their argument, they made reference to Bent, and if you look at the four corners of the Bent analysis, the four corners of that decision, it never raised this specific thorough analysis on 460-30. So I think that relying on Bent is not an appropriate case to rely on.
You know what I'm wondering is it's kind of complicated, but how would this affect other areas? Let's say we allowed this, but let's say we get a writ for error coram nobis, and unlike a 460-30, an error coram nobis, and through there you want to say, I want to file a late notice of appeal. But that has no time limit, and you can do it at any time. And all it would take, there would be no finality if a defendant could have sought the right to file a late notice of appeal. If you do it through a writ through error coram nobis, there would never be any finality ever on appeals. And I don't know if it's really fair to ask you to comment on it because it seems convoluted, but only been here a short time, and the convoluted argument always shows up here. So it doesn't take long. So that being the case, though, I'm concerned about the policy implications of saying could is the same as must. And that's, it seems, logically where we're at.
Understood, yeah. Obviously, the coram nobis issue didn't apply to this
No,
case.
it doesn't apply to you here. You get a 440.
We have a statute on point. Yes. But what I'm asking this court is to impose the bright line rule that I'm seeking is consistent with this court's tradition of protecting the rights of criminal defendants and ensuring that their criminal convictions, with all the consequences that come with a criminal conviction.
Judge Fahey raised a minute ago that the First Department does this routinely.
Yes.
Year and third. Have you done any research as to what the effect has been in the First Department as opposed to the other three?
Well, I know in the amicus we addressed that issue, that once a 460-30 application is made, they granted usually 100%, 100% of the time. As far as the research as to what happens thereafter, we know.
And of course, granting that doesn't make it, it's still the act that they have to make it. It extends the finality, is what you're saying. I'm not even sure it does that, but okay.
Understood.
But it's one thing. It's one thing to extend the right to appeal, so he can go file a piece of paper and then bring up his record and argument in front of an appellate division. It's another thing you want to say that you want to vacate the plea. And I think in Corso, I forget who wrote that, but they were saying this is not 440, this is 460-30, and it's not vacating a plea. It's just giving somebody a right to appeal. And they made a fine distinction there. I thought that we have followed since.
Understood. You know, the prosecution's argument, the prosecution is completely disregarding 460-30 in their arguments. If the prosecution wants to repeal 460-30, then they should seek their
I saw that in your brief.
Yes, their
well,
remedy.
they're not.
With the courts.
460-30 applies to appeals. I think this is, so if you want to appeal, bring a 460-30. If you can show the two elements that are required in 460-30, come on up. If you can't, you can't. You're foreclosed. This is kind of an addendum to that, saying, well, maybe we could, maybe we couldn't, but all of a sudden the year in 30 that 460-30 creates applies to 440s in terms of a Padilla type thing or any other new law that may come down the pike. Right?
Understood. Well, I'm going to respectfully request that this court uphold and adopt the Second Department's holding.
Okay.
Before you sit down, I just want a little clarity here. So when does the clock start ticking for when he has to file his notice of appeal, under your rule?
Under the rule that we're advocating for, a notice of appeal doesn't necessarily have to be filed. Yeah, the rule that we're arguing is that a criminal conviction becomes final 1 year and 30 days after sentencing, irrespective of whether a notice of appeal is filed.
Oh.
Right line rule.
Okay.
Okay, I'm sorry, let me just follow up.
Go ahead.
So, but in this particular case, the challenge that he's asserting, he has no knowledge of that
Yes.
until March 31st, 2010?
Yes, on March 31st, 2010, that's the date that Padilla was
Padilla's rendered,
decided. Yes,
correct.
on that particular date, pursuant to his 460-30 rights, he still had time. His 460-30 time had not expired. Therefore, his criminal conviction was not final on that day, and therefore he should receive the benefit
Why
of the new.
doesn't the clock start ticking on that day, when he knows he's got a basis for appeal?
My client didn't know on that particular day.
I understand. I'm just trying to follow up a little bit on your adversary's suggestion here that the attorney should know at that point, and so the 30 days should apply at that point.
But it's our argument that the attorney was ineffective in this particular case.
How much time did he have to file this 440? I know he filed it on
In April of
13th.
2011.
Right, that's when he filed it, right?
Yes, that's when the 440 was filed.
What was the last date that he could have filed it?
The last date that he could have filed the 440?
Yeah.
It's a 440 motion.
Yeah, but you need the Padilla thing, so, and that's why you need the 460-30. So it would have been a year and 30 days post-Padilla.
I believe the appellate division said that my client, Mr. Varenga's conviction became final on June 14, 2010, approximately 10 weeks after Padilla was decided.
Yeah, you just made it, right?
Yes.
Okay.
Thank you.
Thanks, counsel. Counsel, rebuttal?
Yes, and I guess I misapprehended Judge Rivera's question. But my point is this. Assume Mr. Varenga had filed a timely notice of appeal. Assume he had gone through his appeal and raised meritorious claims, and the conviction was affirmed. That would have nothing to do with his Padilla claim. And so the time frames for determining when to file the notice of appeal and when to file a late notice of appeal shouldn't apply to 440 claims. That is our main contention.
Okay. Thanks, counsel.